The public hearing of the Board of Election Commissioners is now in session. This meeting is open to the public. In accordance with holding a meeting open to the public, if any member of the public in attendance today would like to provide a public comment before we begin the official business at hand today, you may do so now. Otherwise, we'll move on and begin today's hearing. Seeing no one from the public, we will do that. The County of Peoria Board of Election Commissioners is ex officio the properly constituted electoral board pursuant to 10 ILCS 5/10-9. The parties wishing to be heard should have signed an appearance form at the signing table in front. If you have not done so, please do so now. I believe everyone has. The electoral board will conduct hearings for the purpose of receiving evidence and hearing argument relevant to the issues presented by the objections raised in the objectors' petitions. With regard to the substance of the objections, the objector must bear the burden of proving by operation of law and by a preponderance of the relevant and admissible evidence, or the burden of proof, that the objections are true. The board will first adopt rules of procedure for the Board of Election Commissioners of the County of Peoria as the duly constituted ex officio electoral board for hearing and passing upon nominations to nomination papers. I will accept a motion to adopt the rules of order.
Moved.
Got a motion by Dr. Pino,
Second.
second by Jim. All in favor, say aye.
Aye.
Any opposed? Motion carries. Public hearings will proceed in an orderly fashion. I would like to ask your cooperation in the following procedures. All comments should be made from your individual seat, microphones, and any individual making comments shall first give his or her name and address. Please speak into the microphone slowly and clearly. This is required because of an official recorded transcript of the hearing is being made. If there is an appeal, the court must make its decision on the basis of what was said here today. If anyone requires special accommodation in order to speak, please let me know and we will make those arrangements. This is the time for presentation of testimony. No debate is allowed. These rules are intended to promote an orderly system of holding a public hearing to give every person an opportunity to be heard. Each party may make a brief opening statement, should be limited to what the party intends to prove, and should not be a presentation of evidence or of the merits of the case. The objector will present his evidence and or argument, his case in chief, first. The respondent, the candidate, shall be given the opportunity to cross-examine the objector's witnesses and present his or her own witnesses or present evidence, the defense. After respondent has completed his or her defense, the objector shall be given the opportunity to present testimony and or evidence limited to rebutting the testimony and or evidence presented during the respondent's defense or the rebuttal. Each party may make a closing argument. The parties are directed to limit their closing argument to a summation of what he or she believes has been proven. The board will utilize its rules of procedure to conduct and preside over all hearings. At this time, I will call case number 21-01, a hearing on the petition of Phil Reardon objecting to the nominating papers of Abby Humbles. The board will take judicial notice of the following documents: nomination papers, objection petition, voter registration records kept by the Peoria County Election Office. Are there any preliminary matters before we move on to opening statements?
Yes. As a preliminary matter, I would actually, pursuant to Rule 3I and 4 of the Rules of Procedure that were adopted by this board, move to dismiss the objector's petition on the basis that, as a matter of law, it doesn't meet the threshold requirements and no presentation of evidence is necessary. I'll make a brief explanation for why that's the case. The objector's petition only makes one argument, that the address at which Ms. Humbles resided was not the same address that was on her voter registration. And is it okay if I step over here so I can talk to the crowd?
Sure.
Thank you. That is actually, I know that this board has heard me come before it many, many times saying that where the address, and I'm guessing that the objector has read in the news the same argument that has been made, where an address doesn't match what is in the voter registration record. That means that that signature in the nominating paperwork should be stricken, and then you don't count that signature when it comes to whether the person has met the minimum signature requirements. That is not the same standard when you're talking about candidates. And that's why we really don't need a full hearing. So when we're talking about candidates, if we look at the petition for nomination, it talks about, and we're talking about the top paragraph of both the statement of candidacy and the petition signature sheets, okay? If you look at that, where it talks about, and this is really where the meat and potatoes of this whole situation arises. You can love the state of Illinois legislature and their ability to write bad and very unclear statutes. But these forms are made to try to comply with what the state statute requires. What the state statute says, well, we'll go to the form, that the candidate resides we'll go to the statement of candidacy. I, Abby Humbles, being first duly sworn, say that I reside at 5235 West Briarstone in the city, village, unincorporated area of Peoria, zip code 61615 in the county of Peoria, state of Illinois, that I am a qualified voter therein, okay? That right there is really the meat and potatoes here. The argument that the objector is raising, if I am to read the objection correctly, is that I am a qualified voter, I am a qualified voter therein. The question is, what does that modify? Does that modify the political division, meaning, the Peoria, here, the Dunlap School Board, or does that modify the address? 5235 West Briarstone, Peoria, 61615. And I will submit to you, for the reasons I'm about to state, that it only modifies the political division, not the address, the physical structure. The reason for that is, I'm going to cite a case, Dillevo v. County Officers Electoral Board of Sangamon County. The case is 260 Illap 3rd 127, and at page 134 it provides that the Constitution requires only that a candidate be a resident of the district. Residence requires physical presence in the district with intent that such presence be permanent. It does not, however, require that permanence attached to a particular physical structure. And that makes sense, because people can move within the district, and as long as they're still a qualified voter in that district, they're fine. The objector has not said that either residence, whether it's the registration or the residence at the registration, which is, I can't remember the address. The what?
Hunter's Trail.
Hunter's Trail address, or which she's updated, just not that it matters, but the Hunter's Trail address or the Briarstone address is outside of Dunlap School Board District. He has not alleged that, okay? We're not here to talk about a residency requirement issue. So the question is, the question becomes, did any statement in her nominating paperwork either mislead, or was it capable of misleading the people who were signing it, or was it fraudulent? If she had made a statement that she was not registered to vote, or that she was a registered voter in the Dunlap School Board area when she wasn't, that would be fraudulent, and then she would be stricken from the ballot. If she had made a statement that was misleading, for example, we see it oftentimes in a Peoria City Council election, where you have, for instance, in 2017, you had the at-large race, where for a partial term, and you had the mayoral race, and you had all the district races. If you had a candidate that put on their nominating paperwork that the office that they were seeking was Peoria City Council without specifying the district, or whether it was an at-large term or something like that, that would be arguably misleading and subject to being stricken from the ballot. But here, everything, not one thing has been alleged in the objector's petition that there was misleading information or fraud, okay? It's only a technical argument that fails, that because her voter registration didn't match the statement of candidacy, she is to be stricken. But again, because the case law says that the statement of candidacy, or the statement of candidacy, the I'm a qualified voter therein modifies the political division, not a permanent structure like a house, it doesn't matter. Finally, I'm going to cite one other case, Marzalek v. Kellenson. And actually, maybe one more case after this. Marzalek v. Kellenson, 212 Illap 3rd, 836. In this one, a lady she had decided to run. She had gotten divorced and she had resumed the use of her maiden name. And somebody had tried to strike her from the ballot on the basis that her maiden name, as set forth in her nominating paperwork, was not the name that was in the voter registration, okay? It was a different name. And the board actually did strike her in this one. On appeal, the appellate court said, no, that is not right. As long as there's no confusion and no fraud, she should be on the ballot. And the reason they gave is because Illinois courts view the right of a citizen to hold political office as a valuable one, not to be prohibited or curtailed except by plain provisions of the law. And then I'm just going to explain, there's one other case, and this is exactly the reason I've come here so many times talking about striking people whose signatures don't match or their address doesn't match what's in the voter registration. In Lucas v. Lakin, someone made that argument relative to a circulator of a petition signature sheet, which they sign the bottom. And the Supreme Court of Illinois took the position that if you look at the statute just spells out that the address to the right of the signature has to match what's in the voter registration records, because as a practical matter, you might have hundreds or thousands or more signatures, and to maintain a system that would allow us to identify fraud, there's a compelling interest in making that address have to match the voter registration records. That was not the same sort of compelling reason that for circulators, in that the circulator in that case, their address did not match that they listed on the paperwork, did not match what was in the voter registration records. And the Supreme Court said, that's not what we're looking at. We're looking at, maintaining a system where we can identify fraud. And given the substantial compliance standard, although I would say there's been strict compliance here, and the goals of ballot access and ballot inclusion as opposed to ballot exclusion, there's really no basis in the objector's petition, and it should be just dismissed and overruled outright at the outset of this hearing. Thank you.
Mr. Hanauer, can you clarify what your original motion was?
Yeah, it would be a motion to dismiss, and I would say overrule the objector's petition as a matter of law, because it does not set forth any basis in law for it to be granted. Thank you.
Mr. Reardon, I'm going to give you an opportunity to address or respond to Mr. Hanauer's preliminary matters or his motion that was put forth?
I stand by my original objection that the nominating papers did not match the voter registration at the time. I have no further comment.
So the motion is to dismiss. We'll take a vote on
Can I
whether
ask a
we would
question
grant or deny that motion.
Can I ask a question?
Please
Well-
do.
We'll first have someone make the motion and second it, and then we'll have discussion on the motion. But right now, the chair is asking for a motion to consider the preliminary motion to dismiss that was raised by Mr. Hanauer.
Thank you.
So moved.
Got a
Second.
motion by Mark, seconded by Jim. Questions, comments on the motion? Dr. Pino?
My question may show my ignorance, particularly in this day and age when people are becoming homeless. What happens if a person files a petition to be on the ballot and then becomes homeless? Does that make them ineligible because it doesn't match?
So we would have to go into. Elizabeth, you want to answer that question, please?
Sure. So as a homeless individual, you still have the right to register to vote in Illinois. You can claim either your last residence address, where you're staying, or a shelter that you're staying in.
Well, I'm asking about not to register to vote, but to register to be a candidate. Does that same rule apply?
I honestly don't know the answer to that question. That's never come up in our office. I'm assuming if you're homeless within the jurisdiction.
And you're a qualified registered voter.
Right.
Yeah, so.
So this would be the point where the board can discuss, and so Dr. Pinto, if that's a discussion item, you guys can discuss. If you're wanting to go into a closed session and look at, consider legal advice or something like that, but just kind of deciding which direction, if you guys just want to kind of discuss that and have that that conversation among yourselves, or if you're looking for some legal opinion, then we can go into closed session, just clarifying the point in the proceeding where we are.
So to pick up on what Dr. Pinto had mentioned, and there are a lot of circumstances that I think could possibly come up. One is that you file your statement of candidacy and then you become homeless. You file your statement of candidacy and then all of a sudden you're facing a divorce. You move out of the home that you're registered with as a registered voter, and you're renting a place on the other side of it. Granted, you need to still be in the same district. So assuming that this person has moved residences within the same school district as we have here, and it might apply to if you're running for council in the 2nd district and you still resided in the 2nd district, you're going to have a number of circumstances that I think could come up after you've filed your statement and you've moved residences. And I don't want to go into every one of them, but there are several. You become homeless, you're going through a divorce. Let's say there's a domestic situation where one of the spouses is moving into some temporary housing or renting a place to avoid domestic abuse, for example. And I think the statute, the cases that all discuss this, all contemplate that as long as you're a registered voter, and at the time you file your statement of candidacy, you're residing in the district for whatever election you're running for, that it's not going to matter that you have had a change of address and have not yet gone back to change your voter registration records to coincide with wherever your new address is, as long as all of those are still within the same district for which you're running office.
other document, I'm not sure this document that you presented, this is, what exactly is this, the one with Ms. Humble's signature on it?
That is,
Oh, just a second. So we haven't, we're just on his motion to dismiss, so we
Okay.
can't
I
consider,
think all of that is relevant to my question because this-
so we can take the vote and we can vote to deny or to grant the motion to dismiss on the table. If the motion to dismiss is denied, then you'll go into the hearing where there would be evidence presented either through testimony or documents. So I know that's kind of annoying way to get there, but right now we're doing the motion to dismiss. It's basically purely his argument was on the law.
Right, and as a procedural matter, whether or not we need to go into a full-blown evidentiary hearing, if the issue is such that, as a matter of law, the question before us is such that we don't need to hear the evidence because it wouldn't change our finding. So as I understand the question here is, as you read the statement of candidacy, if the statement as provided to us that Dr. Humble says that I reside at 5235 West Briarstone in the city, village, or unincorporated area of Peoria, in the county of Peoria, and that she is a qualified voter therein. And I think that there is statutory and case law that supports the fact that the qualified voter is in that school district. Not that I am, again, reassuring you that I'm registered as a voter at that address, because that's not what the statement says. So I think as a procedural matter with that very precise, because I don't believe that the objection has said that she doesn't live at either of those addresses or that she doesn't live within the district, only that the very precise question is, does the fact that her Briarstone address where she says that she currently lives, and I don't see that there's any question that she doesn't live there, does the fact that that doesn't, is inconsistent with what is on the registered voter records, does that disqualify her? I think that's the very precise question we have, and I think we can rule procedurally that we don't have to get into the evidentiary part of it, because that's not what the statement of candidacy or the statute requires. So I think we could procedurally dispose of the evidentiary hearing to ask where she lives and who lives with her, how long have you lived there, and what. I don't think we need to get into that. I think procedurally we're at a point where we can rule to approve the motion.
So you have a motion and a second already, right?
We do have a motion and a second on Mr. Hanauer's preliminary motion to dismiss, whether we would grant that and dismiss the objection altogether, or we would deny his motion to dismiss and go into the hearing itself. Now, although I agree with you, Jim, I want to make sure that the entire commission is comfortable with having enough answers to make that decision based on the motion that's on the table. And I just want to make sure you're comfortable with the explanation that Jim had given. I agree with that explanation. I think it's relatively cut and dried, but at the same time, I want to honor the proceedings and the process itself. And with Mr. Reardon being pro se and not having legal representation, I just want to make sure that there's a comfort level from the full commission that we would be okay granting that motion to dismiss. If you have more questions, we're here. We can move on to the hearing. Is the point I'm trying to make, Dr. Pinto, and Mark as well.
I'm fine.
I'm fine.
So there is a motion and a second to dismiss the objection. Any other questions or comments on that motion? All in favor of granting the dismissal, say aye.
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 Any opposed? That motion carries.
on, is that Tuesday. Wait a minute. The 12th, is that Tuesday?
Section 1010 of the Election Code requires the Electoral Board must put its decision in writing. That written decision then has to be served upon the parties in open proceedings before the Electoral Board. Since we need time to draft that written decision, I suggest that we briefly continue the hearing of this matter and this is where we need to decide on what date.
I think it's a regular board meeting Tuesday.
Yeah, we do. So our regular board meeting is Tuesday. We could do that at 2 o'clock on Tuesday when we regularly meet. Okay. You okay with that, Elizabeth? I'd like to clarify the decision on the objection has been rendered, so the only purpose for continuing this matter is to allow the Electoral Board to put the decision we made today into writing and to distribute them to the parties. I'd also note that although the statute requires us to provide written decision in an open meeting, the parties may, but are not required to appear, and if they choose not to, the statute also allows for service of the written decision by mail. Parties can also agree to be served with the written decision by fax or email. So I would suggest reconvene on case number 21-01 on Tuesday the 12th at 2 o'clock at the Peoria County Election Commission, which is located at 4422 Brandywine Drive, Suite 1, Peoria, Illinois, solely for the purpose of distributing the written decision to the candidates. Would anybody care to make a motion to that effect?
Was that meeting not meant to be, wasn't it supposed to be virtual?
It is. It is. Thank you.
And that's, we can still give our written decision. We'll present it virtually at the meeting. But if either the objector or the candidate wants to attend that meeting, we can get you the login. Otherwise, you can afterwards tell us that you would like to receive it by email or fax or mail. But yes, good call.
So the motion would come in the form that we would distribute by writing and or email the findings on Tuesday, January 12th at 2 p.m.
Second.
Motion and a second. Any questions or comments on the motion? All in favor say aye.
Aye.
Motion passes. Because we're giving verbal notice here at the publicly noticed hearing, no further notice of the continued proceedings will be provided. So again, the Electoral Board will reconvene Tuesday, January 12th at 2 p.m. This will be a virtual meeting. That concludes our hearing on case number 21-01. And since we have no other cases scheduled today, I'll entertain a motion to adjourn. Motion.
Second.
All in favor, say aye.
Aye.
Any opposed? We are adjourned.